Good day, I am Rodely Angalang from B-Scream 3 Echo. For this video, I will discuss the parole investigation and supervision on Module 5. Parole comes from the French word parole, meaning word, as in giving one's word of honor or promise. In penal philosophy, parole is part of the general 19th century trend in criminology from punishment to reformation. Chief credit for developing the early parole system is usually given to Alexander Maconochie and Sir Walter Crofton. Prison reformers were well aware of the reforms achieved in the European prison systems, particularly in the Irish system. Zebulon Brockway is credited with implementing the first parole system in the US. He proposed a two-pronged strategy for managing prison population and preparing inmates release indeterminate sentencing coupled with parole supervision. The concept of intermediate prisons, assistance, and supervisions after the release were Crofton's contributions to the modern system of parole. In 1907, New York became the first state to formally adopt all components of a parole system. Indeterminate sentences, a system for granting release, post-release supervision, and specific criteria for parole violation. By 1942, all states and the federal government had such systems. By 1927, only 3 states had no parole system. Written reports became required and were submitted to the institute after being signed by the parole's employer and guardian. Pardon, parole, and probation definition. Pardon, it is an act of grace proceeding from the power entrusted with the execution of the laws, which exempts the individual on whom it is bestowed from the punishment that the law inflicts for a crime he has committed. The second one is parole. It is a method by which a prisoner who has served a portion of his sentence is conditionally released but remains in legal custody, the condition being that in case of misbehavior, he shall be imprisoned. It means the word of honor or word of honor. Probation, it is a disposition under which a defendant, after conviction and sentence, is released subject to conditions imposed by the court and under the supervision of a probation officer. Parole in the Indeterminate Sentence Law, Act No. 4103, an act to provide for an indeterminate sentence and parole for all persons convicted of certain crimes by the courts of the Philippine Islands, to create a board of indeterminate sentence and to provide funds therefor and for other purposes. In imposing a prison sentence for an offense punished by the revised penal code or its amendments, the court shall sentence the accused to an indeterminate sentence, the maximum term of which shall be that which, in view of the attending circumstances, could be properly imposed under the rules of the said code, and the minimum shall be within the range of the penalty next lower to that prescribed by the code for the offense. And if the offense is punished by any other law, the court shall sentence the accused to an indeterminate sentence, the maximum term of which shall not exceed the maximum fixed by the said law, and the minimum shall not be less than the minimum term prescribed by the same. Next, the purpose of parole: to uplift and redeem valuable human resources to economic usefulness and to prevent unnecessary and excessive deprivation of personal liberty by way of parole or through executive clemency. Next, the Board of Pardons. The Board of Pardons and Parole is authorized to adopt such rules and regulations as may be necessary for carrying out its functions and duties. A prisoner may be granted parole when the board finds that there is a reasonable probability that if released, he will be law-abiding and this release will not be incompatible with the interest and welfare of society. The period of parole supervision shall extend up to the expiration of the maximum sentence, which should appear in the release document. The board may order the arrest or recommitment of a parole or pardon who commits another offense during the period of his parole surveillance. The board may recommend the cancellation of the pardon or cancel the grant of parole of client if it's find that material information given by said client to the board was false or incomplete. Parole Board of the Philippines may issue a certificate of final release and discharge to a parole or pardon after the client has substantially complied with all the conditions of his parole or pardon. The accessory penalties of the law which have not been expressly cremated shall subsist.